All right, we have a lot to get to today, so we're going to jump right in. Today, we'll be discussing immigrant survivor relief for unaccompanied immigrant children. And before we get started, I have a few housekeeping matters to go over. This webinar is an hour and a half long. If you have any questions for the presenters, please enter those in the Q&A box rather than the chat. This webinar will be recorded and posted later to our website, so keep an eye out for that. We'll also provide a copy of the PowerPoint slides and a very useful handout as well after the webinar. We also will be seeking feedback from you all on how you think it went. We'll share that link at the end. And finally, we are offering Texas CLE credit for today's webinar. I'd like to introduce our wonderful guest speakers from ASISTA, Rebecca Eissenova, Senior Staff Attorney, and Leah Ocasio, Staff Attorney. Before I hand it over to them, I'm just going to give a quick overview of who CILA is in case you are not familiar with us. So CILA is a project of the American Bar Association's Commission on Immigration. We are a legal resource center. We are also a capacity building organization. And we think that every child should have representation. We don't think that children should have to go to court alone. And that's a big reason for why we do this work. We are based in Houston, Texas, although some of us work in other cities and other states. We do provide many of our services nationally. We provide technical assistance regarding case-specific questions relating to children and youth with immigration cases. We also offer 5 national working groups and 1 Houston-specific working group. And that's really to create space for advocates like you all to collaborate around the topics we deal with. We provide trainings like this one, and we also put out written resources. We host a platform featuring pro bono opportunities around the country, and we also provide resources related to pro bono coordination and pro bono work. And in times with increased presence at the border, for instance, when emergency shelters have opened, CILA has stepped up to help. And with that quick intro, I'm going to hand it over to our presenters.
Thank you so much, Nadia, for the introductions. And thank you, CILA, for hosting us on this very fundamental topic. Thank you, everybody, for joining. My name is Rebecca Eissenova, and I'll be starting us off with today's presentation, and then you'll soon also hear from my colleague, Leah Ocasio. We will be trying to answer any questions that you have through the Q&A feature, like Nadia mentioned. We'll try to do that as we go. Hope to have maybe a little bit of time at the end for some live Q&A. But if we don't get to your question, or your organization receives funding from the Office on Violence Against Women, or if you're an ASISTA member or become one, we would encourage you to connect with us after the presentation to ask your question using our one-on-one technical assistance service, where we also can provide strategy consultation on individual cases. So without further ado, let's go to the next slide. And share with you that our objectives in having this presentation for you is that you'll come away better able to understand eligibility and employ practical tips when you're helping a child applicant seek a T visa, a U visa, Violence Against Women Act self-petition for a green card. And I'm going to start calling the Violence Against Women Act VAWA starting now. And VAWA cancellation of removal, also known as special rule cancellation. Next slide, please. So to do that, we will start off with a discussion of T visa black letter law, do some practical examples, move on to U visa black letter law and practical examples, and then discuss the VAWA self-petition law, especially as it compares with SIJ, which you all might be more familiar with. And then we'll end with an overview of VAWA cancellation. So with that, I'll pass it over to Leah.
Thank you. So we'll start off, as Becca said, with a discussion on T visas. Next slide, please. All right, and if you could click to the first point. So we're just briefly going to talk about these elements. So T visa is temporary non-immigrant status for 4 years. For the next point, for those who have suffered a severe form of human trafficking. That is the reason they are currently still in the U.S. and they helped law enforcement detect, investigate, or prosecute the trafficking. Next slide, please. So what are the benefits of a T visa? So before even the T visa is approved, the law enforcement agency can help apply for what's called continued presence. That continued presence will grant an I-94, an EAD, and protection from removal for 2 years. The recipient of continued presence can also apply for certain family members to be granted parole. And there's more information about that in your materials, which you'll get after this session. Oop. Go back. I think we have a runaway presentation. But for continued presence, it has to be the law enforcement agency that applies for this. It cannot be the survivor or their attorney. With the T visa, there's eligibility for public benefits before and after approval. This can include things like TANF, SNAP, Medicaid, job supports, and so on. Upon approval, they get a work authorization, and that's incident to status for the principal petitioner or applicant for T visa status. That T applicant can also include family members to get T derivative status, and they can do that with applying with the principal applicant or after the applicant is approved, but before their status expires. And then finally, even though this is non-immigrant status, it can lead to legal permanent residency after 3 years in T status, or if they meet certain requirements before that. And then after 5 years in LPR status, they can seek naturalization. Just want to note that adjustment of status for T, those provisions are under INA 245L, not 245A. Next slide, please. So we'll be going through these one by one, but these requirements again are that they survived a severe form of trafficking, and they have to have reported that trafficking to law enforcement and remained reasonably helpful with that investigation or prosecution, or they have to fall under one of these exceptions, which is they were under 18 when the trafficking occurred, or they are too traumatized to assist in the investigation. They have to still be within the US on account of that trafficking victimization. And they also have to demonstrate that they would suffer extreme hardship if they were removed. And then finally, they have to be admissible or qualify for a waiver of any inadmissibility grounds they may have triggered. And now I'll pass it back to Becca to discuss this in more detail.
Thank you. Yeah, so we'll start by diving into that element of being a victim of a severe form of human trafficking. So this might not mean what you assume it means. So we have a chart here that we'll consider pretty carefully. And I want to start by looking at 3 words in bold. The first one at the bottom left, you see the word ends. This refers to what ends or goal was the perpetrator trying to accomplish. What were they trying to get the victim to do? Next, a little to the right, you see the word action. That asks what action did the perpetrator use to get the victim into the situation? And then finally, up toward the middle of the slide, you see the word means. So this asks how the perpetrator kept the victim in the situation or ensured that the victim was doing that ends, doing what the trafficker wanted. So knowing that, start at the top of the chart, and you'll see that to count as trafficking for a T visa, it has to be a severe form of human trafficking. But this is not a subjective severity test, not looking at the severity of the actions of the perpetrator or the severity of the harm suffered. Instead, it is a specific legal term of art and just means that in the course of the trafficking, the trafficker used force, fraud, or coercion as the means to get the victim to comply. Alternatively, you will see that even absent force, fraud, or coercion, if the trafficking is sex trafficking, then it also counts as a severe form if the survivor was under 18 at the time that any of the trafficking took place. So it's an important alternative for folks that you all may be working with. So further down the chart, you see there are 2 types of trafficking, labor and sex, and the qualifying ends are defined differently for the 2 types. So for labor, qualifying ends would be involuntary servitude, peonage or debt bondage, or slavery. These have specific definitions in federal criminal law. It's cited in your materials. For sex trafficking, the ends is just commercial sex, which means sex in exchange for something of value. Now, the actions for the two types of trafficking are very similar. So the perpetrator needs to have recruited, harbored, transported, provided, or obtained the person for their illicit ends. For sex trafficking, there are a couple additional actions, which is maybe they patronized or solicited the person for commercial sex themselves. And one thing I do want to point out here, this does not require the movement of people, right? So the victim could be confined in a single space, and that could be harboring, which is a qualifying action. And so for T visa purposes, very important to remember, human trafficking is not the same thing as human smuggling. All right, so next slide. So now we'll talk about that reporting and cooperation requirement. This says that your survivor client must come into contact with a law enforcement agency, which I'm going to start calling an LEA, regarding the trafficking. The LEA can be federal, state, or local, and they just have to have the authority to detect, investigate, or prosecute trafficking. They don't even necessarily have to have criminal jurisdiction over trafficking crimes. So an example of an LEA that could count for this requirement that doesn't have criminal jurisdiction would be a Department of Labor agency looking into labor trafficking, right? And ICE is another one. If you're trying to identify where your client could report trafficking in order to meet this requirement, there's an entity called the National Human Trafficking Hotline that can help you identify places to report based on the type of trafficking involved in your client's location. And that information is in your material. So on top of reporting, your client thereafter does have to cooperate with all additional reasonable requests for assistance in the LEA's investigation or prosecution. If the LEA doesn't really make any requests of your client, and sometimes it is the case that a report doesn't really go anywhere, this is still satisfied for your client. But if they do ask for anything and your client declines that request, then you're going to have to argue in your T visa application that this was not a reasonable request. And that assessment is made under the totality of the circumstances test. And you're going to want to think about your survivor's situation when the request was made. Think about everything that was going on for them, and also think about whether this kind of request is typically made of other survivors in their shoes. To prove this reporting and cooperation requirement, there are a couple different ways, a little bit of flexibility here. The main way and the most formal way is to use an immigration form I-914B, also called an LEA declaration. This is a form that the LEA signs that verifies the client was a survivor of trafficking who did remain helpful in the investigation. But that's an optional form to have signed. And if you're familiar with U visas and know about this from that context, it's not optional in the U context, and we'll talk about that, but it is optional in the T visa context. It also doesn't expire in the T visa context. So if you decide that you can't use that option or you don't want to, you could use other evidence to meet this reporting and cooperation requirement. That might be something like your client's declaration of what they did to report and cooperate, their statement that they remain willing to assist. Might be your own affidavit if you helped them report, where you verify what steps you took to report. It might be copies of emails if you were reporting via email or collaborating with law enforcement via email. Anything that's credible on this point can be used to show they meet the requirement. Next slide. Now, as Leah mentioned, there are some important exceptions here, especially important for folks who all serve. One of them is that if the survivor was under 18 when at least part of the trafficking occurred, they just don't have to meet the reporting and cooperation requirement at all. And another exception is if the survivor is too physically or psychologically traumatized to be able to work with the LEA. And for both of these exceptions, you could theoretically have your client start off cooperating, make a report to the LEA, and then stop and use one of these exceptions when you still apply for a T visa. And there is one document in your index of materials from an anti-trafficking organization called CAST that I would recommend you take a look at that explains some considerations to help you and your client decide whether it might be better in their case to report and cooperate or to use one of these exceptions. There's a lot of factors to consider here, depending on your client's mental health needs or their goals for getting justice through the criminal justice system for what happened to them, or their goals for bringing certain other family members. And that document from CAST walks you through that decision making. Next slide, please.
And so now we'll talk about that other requirement that they are currently or still present in the US on account of the trafficking. What does this mean? This includes if they were trafficked into the US, if they were trafficked while they were already in the United States, or they were trafficked elsewhere but were brought into the US for the purposes of the investigation or prosecution of that trafficking. So if they've never left since then, this includes showing that the trafficking situation remains ongoing, showing that they were liberated by an LEA from the trafficking, that they escaped the trafficking, and that would be before any law enforcement was involved. And then they could also show that they were a victim of trafficking and their continued presence is related directly to that original trafficking. For example, they're accessing recovery services, or they can even show they're participating in that investigation or prosecution process. But what happens if they've left or were removed after this trafficking, even if they've returned? So remember, they have to be physically present, so you can't apply for a T visa from abroad. If they left after the trafficking and are returned, the presumption is that they are no longer physically present on account of the trafficking, unless they can meet one of these three exceptions. So those exceptions are that re-entry to the US was a result of continued victimization by the same trafficker. So it has to be the same perpetrator, but it doesn't necessarily have to be trafficking. And so want to include the extent of the applicant's continued fear of that perpetrator or any connections to that trafficker, any threats of harm the trafficker poses to the applicant or their family to be able to demonstrate this exception. Another exception is that they're a victim of a new severe form of trafficking, so it'd be a different perpetrator, or that their reentry was allowed for participation in the investigation or prosecution of the trafficking. This element of being present on account of the trafficking can be a difficult one to meet, particularly where the trafficking isn't ongoing and they were escaped from the trafficking or have been removed from the trafficking for a significant period of time. We don't have time to get into a lot of nuance of what to show here, but we did put reference and resources in the materials to review of what to consider in showing that someone is still present on account of the trafficking. Next slide, please. Another element is this extreme hardship. So the question is, would the applicant suffer extreme hardship involving unusual and severe harm if they were removed? So this is pretty similar to other hardship analyses, extreme hardship analyses. And so you can kind of follow along those factors, though certainly include factors specific to trafficking survivors, that victimization, the need for resources, and so on. The hardship, they must demonstrate it to themselves, so to the survivor themselves, but keeping in mind a totality of the circumstances for why they would suffer this extreme hardship. Slide. So another important factor is whether they're admissible. And if they aren't, there are two waivers available to T applicants. So the first is this D13 waiver. And this is specific to T applicants, so anyone pursuing status that way. And USCIS will consider this first. So if someone is inadmissible and applying for a T, USCIS will consider whether they will waive that ground under D13 first. So this D13 waiver, the inadmissibility ground must be caused by or incident to the trafficking, unless we're talking about health-related grounds of inadmissibility. And it has to be in the national interest to grant the waiver and the T visa. And I think reference in materials as well, the policy manual from USCIS actually goes into these different waivers and what they consider and what is national interest. And so it's good to review that as well. As we note on the slide, there are certain things this waiver won't cover, including security grounds, thinking like national security, if they renounce their citizenship, if there was child abduction. But usually what we see is where something can't be waived under D13, it's usually because there isn't this connection to the trafficking that they can demonstrate. And so then USCIS will consider whether to waive that under the D3 waiver. And the D3 waiver is a general non-immigrant waiver. It is not specific to Ts, but a T visa is a non-immigrant visa, so it is available to them. These factors on the screen come from Matter Franca, so USCIS will consider how serious the violation is, risk of harm to society, and determine whether or not to waive any ground that couldn't be waived under D13 under the D3 waiver. Again, it's important to note, though, this D3 waiver cannot waive most security grounds, and so want to really establish what they're inadmissible for. Other than the public charge grounds of inadmissibility, T applicants are not automatically exempt from any inadmissibility ground. And for children too, they might not be reliable reporters of their own history, immigration or otherwise. And they're not automatically exempt from, for example, being present without admission or parole solely based on their age. And so it might be it's important to FOIA to know what grounds may have been triggered to know what might need to be waived. Next slide. And so even though we're talking about two different waivers available, D13 and D3, they both are on the same form. So the form I-192 to get any inadmissibility grounds waived, it's all granted in USCIS's discretion. And so you want to make those arguments specifying not only which grounds your client has triggered, but also if you're relying on D13 to waive a ground, you will want to make sure you demonstrate that caused by or incident to the trafficking, and where D3 arguments are necessary, considering those factors and providing that information for both. And now I'll pass it to Becca for some practice scenarios.
Thank you. Yes, so we are now going to get your direct involvement here using this poll that just popped up for you. So I'm going to read this question aloud with you and then let you think about it for about 15 seconds and weigh in on the poll. So your client is 17 years old. Recently, she was at a party and a friend of a friend approached her, said he would give her $300 worth of drugs if she went all the way with him in the bathroom. She got scared, she ran home, she never saw him again, and she never told police. Question is she eligible for a T visa? And I want you to keep in mind the required ends, means, and action, and the LEA reporting requirement. And we'll close that, thank you. So it looks like most people think no. Nadia, can you please reveal the answer here? I think it's going to be a surprise to some of us because this doesn't sound necessarily like what we commonly think of as trafficking. But quite possibly the person is eligible because this friend of a friend described an ends that meets the definition of commercial sex because it's something of value in exchange for sex. And he completed his portion of the action because he solicited commercial sex from a child under 18. It doesn't matter that she escaped instead of complying. Also, because this is a sex trafficking pattern, the fact pattern, the requisite means is satisfied just by the fact she's a minor. No force, fraud, or coercion is required. And then finally, also because she's under 18, she doesn't have to meet the reporting and cooperation requirement, even if she decides she never wants to tell the police. So quite possibly eligible. Let's go to the next slide, please. Got a shorter fact pattern here. If we could please launch poll 2. Your client is a food delivery driver, and he was forced to deliver drugs in addition to the food while out on his routes. Could he have a T visa case, potentially, assuming that he reported? Give you another 15 seconds here. All right, and it looks like most people this time answered yes. Okay, so Nadia, can you please reveal that? I agree. I think quite possibly he could have a T visa case. An illegal act, like transporting drugs here, but also prostitution, participating in human smuggling, other illegal acts, those could constitute the ends in a labor trafficking analysis, as long as it amounts to involuntary servitude. But I think on a practical level, there could be some hurdles to approval of a T visa application, especially where an act is very dangerous or serious, which drug trafficking sometimes can be, or if it makes the person inadmissible, which drug trafficking does. But there is that waiver that Leah mentioned that specifically takes into account the connection to trafficking for both the waiver standard itself, but also for the exercise of discretion in general. And so it can be a difficult one to win, but possible. I think if you have a client in this sort of situation, one important thing to do is to help them weigh the risk of reporting and applying for a T visa and possibly failing in their T visa, taking into account the political environment at the time they're applying and where they are when they're reporting. You may want to consult a local criminal defense attorney. Think about all those factors and let your client decide. All right, very good. You guys did well on those. So let's move on, thank you, to U visas. So next slide, please. What is a U visa? We'll go ahead and click through. This is a temporary non-immigrant status that lasts 4 years. It's for people who suffered a violent or serious crime, where the crime occurred in the US, and the person helped law enforcement detect, investigate, or prosecute the crime. Next slide. And that probably sounds a little familiar, right? And in some big ways, yes, U visas are similar to T visas, but they are also different in some other big ways. So we've put together this Venn diagram to help you compare the elements. So in the middle here, you see both are 4-year visas, both are pathways to citizenship in the same kind of time frame. Both require cooperation with an LEA regarding the crime that they suffered, and both require the applicant to be admissible, or if not, to file a Form I-192 waiver request. But that's kind of the end of the similarities because differences are more pronounced. So T visa we just talked about, they have to be a survivor specifically of human trafficking. Whereas for a U visa, they could be a survivor of a variety of serious crimes. For the T visa, that LEA declaration or certification, it's optional, but for a U visa, it's required. Meaning you need to have an LEA sign off on a form saying your client was cooperative in order to submit a U visa application. For a T visa, we saw an element proving extreme hardship to your client. That's not a requirement in a U visa application, but instead there's a different requirement, which is that the client suffered substantial harm because of the crime. For a T visa, we talked about they have to be in the US when they're applying, and it has to be on account of trafficking. For a U visa, they don't actually have to be in the US at all. They can apply from outside of the US, although the crime does have to have happened at a time when they were in the US. Then that waiver, it is the same form that's used, but it's yet a different waiver standard to get approved. So Leah just went over the T visa standard. For a U visa, the standard is whether the waiver is in the public or national interest. And we'll talk about that a little more. Finally, T visa has some robust public benefits available, even at just the application stage, certainly after approval. And a U visa, very sadly, at least on the federal level, has none of that really. And only if the person is in a certain state with more generous public benefit options will those be available. Next slide, please. So some fast facts about the U visa. Who is it for? Well, I just mentioned it's for a survivor of a variety of serious crimes. Actually, there's a list of qualifying crimes that appears in the U visa statute. It's not just any serious crime, it has to be listed. Here, a survivor, though, is defined somewhat broadly. It does mean a direct target of a crime. That'd be a direct victim. but also a bystander victim or an indirect victim can apply for a U visa. A bystander is generally someone who was present on the scene or very soon after, who suffered an unusually direct injury because of the crime, even if they weren't the target. And then an indirect victim is somebody who has a close family relationship with the direct victim and who also suffered substantial harm, and who then also stands in the place of the direct victim to be helpful with the LEA and the reporting requirement, specifically because the direct victim is either incapacitated, such as by being a minor, or deceased due to the crime being homicide. And then also, U visa could be available to someone who is not any kind of victim, but is a derivative on an application, which we'll talk about more as well. When can you apply for a U visa? Under the statute, you can apply anytime after your client has reported the crime. But technically, or practically, it's often not quite that easy. Many LEAs will set additional criteria as to when they will sign that required certification. Some say, if the crime happened too recently, they haven't proven their cooperation, they won't sign until it's done. Sometimes if the case happened a very long time ago, they'll say, nope, we just won't sign after a certain number of years, and they get to set these internal policies. You can try to educate them to change those policies, but in a practical way, this can be a barrier sometimes. Now, how do you apply? We've put some sample application packets into your index of materials, or at least the cover letter and index. You're going to use Form I-918, and then you have to submit some evidence that's required, and then some evidence that you get to pick and choose on the other other elements. So the required evidence is that LEA certification I mentioned to show victimization and cooperation, as well as a client declaration. All the other elements, substantial harm, that kind of thing, those can be proven with any credible evidence you have that's on point. Next slide. So to dive into a little more, the qualifying criminal activity that counts for a U visa. I mentioned this appears in the statute. So here is the statute. And you see this long list of crimes that can qualify someone. We see rape, torture, trafficking. These are all very serious crimes, but you'll notice they are listed here by generic names. They're not listed by a citation to a particular federal statute or state statute or definition, with one exception of fraud and foreign labor contracting. And so the typical way that you analyze whether your client was the victim of a qualifying crime is to ask, did the crime my client suffered get reported as and charged as a crime with one of these names, just under the way the state defines that crime? So often that question is easy, but sometimes it's not, such as if you think your client suffered one of these crimes, but the LEA for some reason didn't end up charging any of these crimes. And so there are a few highlighted words at the top of the statute here that can help you make the argument that your client is still eligible. So the first word is involving. If you can show that one of these qualifying crimes under your state's definition was committed during the course of whatever else ended up being charged, then USCIS might accept that the activity involved a qualifying crime. Second, any similar activity. So if your state criminalizes the conduct described here, and that's what your client reported, but your state calls that conduct something different by a name that doesn't appear on this list, you may be able to convince USCIS that the elements of the state statute in your case are still similar enough to a crime on this list that they count for a U visa. So an example might be the conduct described here is called felony battery in your case. You may be able to argue that it has all the same elements of a typical felony assault. But you need to be aware that although this says any similar activity, which sounds very broad, USCIS essentially looks for an exact categorical match between the elements of two statutes when someone tries to make this argument. So it's much narrower in practice than many of us would like. And then the third set of words to help you argue are federal, state, or local criminal law. So in theory, the inclusion of these words could allow a person to argue that what their client suffered was defined in a different jurisdiction to match one of these statutory crimes, even though it's not defined that way in their state. However, this is often very difficult to win on. USCIS usually likes to use a definition that is used by whatever jurisdiction investigated the crime. And it makes exceptions in a very few set of cases. We did put one into your index of materials that you can look at and try to imitate those arguments. It's a case from Virginia where actually the person succeeded in arguing a qualifying crime occurred under the definition in the model penal code. So you can get creative, but all of these are sometimes longer battles where you have to do an appeal before you win, or just in general uphill battles. Next slide, please. So I will turn this to Leah.
All right, so some fun facts about the U visa. Similar to the T, this can at least eventually be a pathway to citizenship. So after 3 years in actual U visa status, they can seek legal permanent residency, and those provisions are under INA 245M. And then after 5 years in that status of legal permanent residency, they can seek citizenship. Similarly to the T, they have to show admissibility or get their any admissibility grounds they've triggered waived to be eligible for the U. So almost any ground can be waived through the U if it's in the public or national interest. And if you can click for the next graphic, so all of those grounds that are listed are waivable in USCIS's discretion. So if they entered without inspection, if they have a prior removal or removal order, criminal history, smuggling can all be waived. And for the next graphic, what's important to consider, though, is because this is all in USCIS's discretion, where there is a significant history of immigration violations or multiple inadmissibilities that must be waived, the more you'll have to demonstrate the positive discretionary factors and evidence to balance that out. And this box on the screen just is examples of what to consider in developing that argument, in developing the evidence in support of a waiver application. Next slide, please. So some harder facts about the U visa. So first of all, if there isn't an investigation by law enforcement, there isn't a case. The client has to actually have contact with an LEA. This isn't optional, and unfortunately, unlike the T visa, there aren't exceptions based on age or trauma. But law enforcement and investigation are terms that are more broadly defined, and we'll discuss that in a moment. So one thing to consider is the client must report their victimization, and then they must remain helpful after reporting. So here, this means that they report and they don't stop cooperating as long as there are reasonable requests that the law enforcement agency is making through their investigation or prosecution. Again, there aren't any exceptions for age or trauma. And wanted to note that this parenthetical here of parent, guardian, or next friend shows that for child survivors, typically defined as under 16, or for those who are otherwise incompetent or incapacitated, these individuals, be it the parent, guardian, or next friend, can essentially step in to meet these requirements of the reporting and the cooperation. And so it's not an exception like we see with the T, because someone still has to meet those elements, but it's a way to say the child themselves may not be able to do so. And then finally, the LEA has to actually sign the certification. And so this is the Form 918 Supplement B that the law enforcement agency must sign to prove or to state that they do agree that the client was a victim of one of the qualifying crimes, that they actually were or are helpful and cooperative, and how that is the case. Again, another difference from the T, this certification is not optional. If they the individual cannot get a signed certification from a law enforcement agency, then that individual will not be able to apply for the U visa. Where there are LEAs that have less than helpful policies, or maybe don't yet know what the U visa is, it may mean some education to that agency or to those officers about the U visa, what its actual requirements are, how it is a law enforcement tool. And we also have resources for that on our site, and can reach out for that. And one thing to note too, that once you have that certification, that signature expires after 6 months from the date it was signed. And so USCIS has to receive it prior to that date. Next slide, please. So some more detail here. We mentioned that these terms law enforcement and investigation are more broadly defined. So for law enforcement, this means an agency that has the authority to investigate crimes. And that could be at any level, federal, state, local, tribal. And there's the examples we typically think of: the police department, a prosecutor's office, perhaps judges, but there are other agencies as well, named specifically in the statute or regulations, rather, and otherwise. So the Department of Labor, for example, or child or elder welfare agencies. And so thinking of children, Department of Children and Family reports, thinking like CPS, ACS, or agencies with that authority, whatever name they may have. The reports that they make can be the basis of a U visa certification and subsequent petition. Investigation is defined here as detecting, investigating, prosecuting, convicting, or sentencing. And this includes even where there's a detecting of a qualifying crime, but has to be referred out because of the nature of it, thinking civil versus criminal, or a jurisdiction issue, a geographic issue. Even though investigate does include this prosecution, conviction, sentencing, whether someone is actually prosecuted or convicted or sentenced is actually irrelevant to whether an investigation occurred. So the perpetrator of the crime may have died, they may have fled and can't be found, or maybe they themselves were also a minor and couldn't be charged criminally, in a sense, instead were adjudicated in like delinquent in a juvenile proceeding. That doesn't mean that an investigation didn't occur and that the victim of that qualifying crime is not eligible. So all of this to say is there are more options than just the police department or prosecutor's office. And we say this too because even where there was a formal investigation in the typical sense, that police department, for example, may have internal policies that make it difficult, if not impossible, to get that signed certification. And education and advocacy may not be successful in that individual case. And so being able to utilize another law enforcement agency potentially for this certification can open up other avenues for someone who may not be able to get it through the police, either for those policies or maybe just fear of reporting. Next slide, please. So we talked about the benefits of the U visa, but one thing to keep in mind, this first point, is that there is a cap every year of just 10,000 U visas. This only includes principals, so derivative family members are not included towards that cap. But this cap has been reached every fiscal year since I think 2011, back when it started essentially. So there is a very long wait list, and they are currently approving U visas that were filed in 2016. There's now two different kind of policies in place. There is the wait list and the pre-wait list bona fide determination that are concurrently in existence. So the bona fide determination right now is a little over around 5-year wait. So that still is delayed, even though it can be sooner than a U visa adjudication. So for the bona fide determination, if someone's within the US, USCIS verifies the required forms and evidence have been filed to show a prima facie case. They run the biometrics to do that background check and make sure there's not a security reason to deny, that positive discretion is warranted. So with that bona fide determination is not is deferred action as well as a 4-year work permit. Again, we've been hearing reports of some sooner adjudications, but generally these determinations are being made in 2018 or 2019 for those cases filed then. And so all this to say is there are benefits here, but clients need to be prepared for a pretty long wait. And so they may want to be able to check these processing times online themselves, or schedule certain check-ins that they can call and see what's happening, if anything's changed, as people advocate for different ways of either raising the cap or raising how many can be granted. Next slide, please. So briefly, just touching on derivatives, this is very similar to the process for Ts, but here I wanted to note too, not just that the relationship and the age to the principal is what matters. And so important to look at that. Derivatives can also get that bona fide determination, which includes a deferred action and the work authorization if they're in the US, as long as the principal has received that bona fide determination. Recently, USCIS updated the policy to say the principal doesn't have to receive the EAD based on the BFD in order to review the derivatives, but the principal must be granted a bona fide determination before derivatives can be. And so with that, I'll pass it to Becca.
Thanks, Leah. Go to the next slide and ask some more questions. Yep, thank you. This is poll 3. Fact scenario, your client was the victim of a qualifying crime. You're sure of that, but it happened in their home country. Can you pursue a U visa for them? We're going to do this one in pretty short time, just about 10 more seconds. Right. All right. Okay, this is very good. So most people said no. And Nadia, can you please reveal the answer? I agree with no. The criminal activity for a U visa must have occurred in the US. Although the person could apply from outside the US after it occurs, the crime has to have happened here, or meet one of these other nuanced exceptions on this slide. So if you've got someone with a crime abroad, you could consider SIJ or asylum for them instead, depending on their age, of course. If it was domestic violence, maybe even VAWA, which we'll talk about soon. All right, so Leah, I have a question for you. So what if the crime happened here, but it happened more than 10 years ago?
So per the statute and regulations in USCIS policy, that shouldn't affect whether they're eligible for, that alone shouldn't affect whether they're eligible for the U. I think here's where we flag again that internal policies for a law enforcement agency might mean that they don't sign for older cases, or if they sign at all. So that's something to consider, is that for USCIS purposes, as long as they can meet all the other requirements, they should be eligible, but to get that certification, that might be a hurdle.
Okay, that makes sense. All right, let's move on to the next slide, please. So we can launch poll 4. The question is, your client was the victim of domestic violence, which is a qualifying crime. A teacher called Child Protective Services, which then brought the case to police, and then a conviction resulted. Who can sign the U certification here? Give you another 15 seconds. Think about this. Okay, all right, good. So we've got a lot of people saying the police, and then a lot of people, even more people, saying all of the above. So let's reveal the answer. I tend to think in this case, the person's fortunate and probably does have 4 choices. So CPS, police, prosecutor, and the judge, they all do things that meet the investigate definition that Leah told us about. So they're all potential use certifiers. So in this scenario, what you'd want to do is read their reports and other documents associated with the part that they played in the investigation, and then consider each of their own internal policies on whether they sign certifications and under what circumstances, in order to pick which one you want to request the certification from first. If you get a denial, move on to another one. All right, let's do next slide, please. And we'll launch poll 5. In this situation it's still a child's victim of domestic violence. Can the child's non-abusive parent be a derivative on the U visa? And what about their abusive parent, assuming that their abusive parent has shown that they are reformed? Give you a little longer here, maybe 25 seconds. More seconds. Okay, great. All right, so we had a much more even split here of answers, and it was kind of a tough one, but let's reveal the answer. So here, the non-abusive parent can be a derivative, so it's option 3, as long as the child is still under 21 when they apply. However, a perpetrator of a crime that forms the basis of a U visa can never be a derivative. And so the abuser here, even if they're the most reformed person that you've ever seen in your life, they could never be a derivative on this application. All right, thanks. Let's go to the next slide, please. I think we've got one more. All right, and we can launch 6. Your client was the victim of an assault with a deadly weapon, which is a qualifying crime, as long as it's a felony assault, which we are assuming. Police do investigate this, but they are unable to identify the perpetrator despite the client's description. Can the police still sign the certification saying they were helpful, saying they were a victim, if there are no arrests and no charges? All right, great. And so most people answered yes, and I agree. The police can sign regardless. So the victim has to report the crime, and they have to remain as helpful as they're able to be and as is reasonable. But there is no particular outcome required, either in an investigation or a prosecution. And in fact, even if prosecution was impossible because the perpetrator was dead, for example, an LEA can still sign and the person can still apply for a U visa. So good job, everyone who answered yes. And Leah, I have another question for you. Let's imagine this assault happened at a school, and it's a school resource officer that comes to the scene. But then eventually, the school deals with the incident internally. They issue just a punishment of suspension instead of any criminal charges. Can the school resource officer or someone in their larger police organization sign a certification?
I would think yes. I think usually SROs are likely an officer with the local police department as well, and have the authority to investigate, refer the case. And so I don't see that being the barrier. I think it could be tricky if there's something that says they don't involve, the larger law enforcement agency. Potentially here, we're also talking about a minor perpetrator, and that can be its own issue, but I don't see why not. But I think there's some questions of their role as an investigative authority.
Okay, can you say more about why it would be difficult if the perpetrator was a minor?
Yeah, in my experience, the difficulty usually is the comfort level of the law enforcement agency in providing that information. So usually documents are redacted of the perpetrator's information, or they just either internal policy or otherwise feel that they cannot provide that information to sign a certification. So again, I don't think this is from USCIS on any level saying that a perpetrator who's a minor somehow now exempts somebody from eligibility for the U, but policy-wise, at the agency level, that could be something that takes significant advocacy.
Okay, so more of a difficulty in getting the required documentation than actual eligibility. Okay, great. Thank you. All right, let's go to the next slide, please. We wanted to close out our section on T's and U's by offering some considerations in removal proceedings. So the first thing to know is that regardless of whether your client is in removal proceedings, USCIS is going to have exclusive jurisdiction over their T or U visa application. What this means is in removal, you will be pleading the fact that you've applied for a T or a U as collateral relief. Then you'll seek continuances, administrative closure, or termination before EOIR. And there is a special case on U visa continuances and administrative closure called Matter of Sanchez Sosa that appears in your materials. You can take a look at that. And also a little fun fact, although it's imperfect in practice, there are policies that support the idea that a U or T applicant who's in removal proceedings could get an expedited decision on their U or T applicant by asking for ICE's assistance in requesting the expedite. So both USCIS and ICE have policies on this, and they say that if ICE makes the request, then USCIS seems to just always grant that request. It doesn't appear to be discretionary. There's no need to prove humanitarian factors like you would if you were making another type of expedite request. And then USCIS, upon receiving it, the person's detained will make a decision in 30 days. If they are not detained, then in 45 days or before the next hearing. And of course, when I'm saying decision, I mean a T visa decision perhaps, but for a U, it would more likely be one of those interim benefits, the bona fide determination or wait list, because due to the cap, they probably can't make a decision on an expedited basis for the full U. So that could be a kind of cool tool, although in practice, ICE seems to claim that they're not aware of this. So we've put a copy of these policies, both the USCIS one and the ICE policy, into your materials so you can educate your OCLA attorney, maybe even ask the judge with a motion to compel for ICE to make the request to expedite the decision. Another thing to keep in mind in removal proceedings is that, so a T or a U application is always decided without a hearing and without an interview, which means that documentation is very important, and you will be tempted to submit very detailed declarations and things like that in your application. But you need to be deliberate and cautious about what you include in your application, details and things like that, if your client's in removal proceedings. And that's because you may end up submitting a copy of your entire application to the IJ when you're asking for a continuance or administrative closure under the case that I mentioned. You don't want anything that appears in that U or T application to raise any red flags to OCLA or the IJ for some reason. All right, next slide, please. So that's for folks actively in removal proceedings. What if they have an existing order of removal from the past? So this depends if the order was unexecuted or executed. If it was unexecuted, there's really no need to do anything while you wait for adjudication. You don't have to reopen the removal proceedings in order to get an approval of the T or the U. And then once the T or the U is granted, if the order was issued originally, if the removal order was issued by DHS, talking about like expedited removals mostly, then the grant of the T or U automatically cancels that order by operation of law and proof it disappears. If the order was issued by EOIR, you will have to reopen it, get it vacated, and terminate. You can do this either after the T or the U is granted right away, or you can wait until the person goes through the adjustment of status process for their T or U adjustment. And usually you'll have to get the help in reopening of OCLA, or you'll have to apply as a sua sponte motion to overcome time and numeric bars. Now, if the removal order was executed, then probably at least one inadmissibility ground was triggered. And so I've got a list of them here on this slide for you. Just check which ones were triggered in your client's case, and then ask on your Form I-192 for these to be waived. If the order was an in absentia order, just keep in mind, special fun fact about those, that poses a 10-year bar to adjustment as long as the person got all the notices of failure to appear. And so if you have a T or U recipient you may want to consider doing a joint motion to reopen, vacate, and terminate as soon as their TRU is granted. Otherwise, they're not going to be able to adjust status in that third or fourth year with status. All right, next slide, please.
All right, so we'll start here talking about VAWA, the Violence Against Women Act. And in this section, we'll actually be referring to two forms of relief. So the VAWA self-petition and VAWA cancellation. But they are separate forms of relief, even though they both say VAWA. So next slide. What is a VAWA case? Usually we're talking about a green card process or adjustment of status that would have been pursued through a family-based case. So a spousal petition, for example, where the petitioner is committing battery or extreme cruelty. And so part of that might be that they aren't continuing that family-based case. And here, this VAWA self-petition essentially allows the immigrant themselves to do the petition. So it's self-petitioning instead of relying on the abuser to petition or to continue through that process. Next slide, please. Despite the name, it's important to note this is not just for women. Any gender who meets these requirements can petition through this process. So there are three categories. One is abused spouses or recent spouse. It's important to note for all of these, the abuser must be a U.S. citizen or a legal permanent resident. So for the abused spouse, the abuser has to be a spouse that had one of those two statuses. If there was a divorce, the self-petition must be filed within 2 years of that divorce, and you have to show the divorce was connected to the abuse. There is no tolling, unfortunately, so that is a hard 2-year deadline to file. For abused children, the parent must be the U.S. citizen or legal permanent resident who is the abusive parent. The child must file before they turn 21. There is an exception to file between ages 21 and 25 if they demonstrate abuse was one central reason for their delay in filing. It's important to note this doesn't change the requirement that the abuse occurred before they turned 21, because that would be what their eligibility was based on. This does include stepchildren and adopted children, not just biological children. And then for abused parents, it's the child that must be a U.S. citizen. Here, not for LPRs, it's just U.S. citizens. And the other caveat is that the child must be over 21, because remember, this is taking the place of a family petition process, and adult children, U.S. citizen children, are the ones who can petition for their parents. This does include, again, stepchildren as well. Parents cannot include derivatives here, so they couldn't include non-abusive children in their self-petition. Next slide, or next, I think just shows, yep, that derivative process. So abused spouses and children can include children that are unmarried and under 21. Parents cannot have derivatives, unfortunately. Next slide, please. So what is the process here? Here we have to show file that's self-petition is that form I-360 that takes the place of the I-130 family petition. And then if possible, it would be that I-45 or DS-260 to get that green card. So I-45, adjustment of status in the US, DS-260 abroad. This can be done at the same time, that filing of the I-45, if they are in the US and their priority date is current. If the child is a derivative on a spousal petition, they don't need their own form I-360. They just need to be listed on their parents' I-360. Next slide. So again, eligibility, have to show a qualifying abuser, so that relationship and status. The qualifying abuse, so battery or extreme cruelty, which the policy manual does define and give examples of. They also have to show this cohabitation or joint residence with the abuser. For children, there is a requirement that the abuse happened during the joint residence, which includes periods of visitation. So that's important to keep in mind. There's arguments that is ultra vires, but that is the current USCIS policy, and so wanted to flag that. Good moral character is presumed for any self-petitioner under 14, which includes derivatives. Otherwise, have to show that for 3 years. And good moral character is defined in INA 101F as what basically goes against good moral character. And then if the abuser was the spouse, they have to show that they married in good faith. Next slide. So that battery extreme cruelty, you have the regulatory site there. So here, unlike where we're talking about the U visa needing some certification, some law enforcement agency involvement, that isn't required for VAWA. So battery or extreme cruelty, battery meaning acts of physical violence, extreme cruelty being the opposite, so non-physical violence, so that can be threats of violence, different forms of coercion, mental abuse, emotional abuse, showing this pattern of control over the victim. If the harm was predominantly mental, you might want to consider submitting a psychological evaluation or treatment record, but keeping in mind to discuss that with your client and know what else might be disclosed in that process, and be as protective as possible as well. Next slide. So what are some milestones? So after filing, it's possible to get a prima facie determination. This is not any guarantee that it'll be approved in the future. It's just saying, okay, we have all the information, the packet was properly filed, there is the evidence needed to meet these elements. It's not a status in and of itself, and it doesn't give you a work permit, but you can get certain public benefits through it. And it's initially valid for 1 year, but can be renewed. I also want to note that this is taking a long time. So VAWAs themselves are taking, I think, about 3 years now. Though these prima facie determinations should be within about 3 months, though that's not always the case. The VAWA, so if someone's not eligible to file their adjustment application at the same time, the VAWA pending doesn't give a basis for a work authorization. You'll want to make sure that the client checks yes on the actual form I-360 that they want that EAD upon approval. And so they'll get that C31 VAWA-based EAD automatically on approval, and which they can renew. There is a possibility to get deferred action as well. Derivatives will need to affirmatively request that. That isn't automatically granted. Now I'll pass it to Becca.
Thank you. So assuming you do eventually get that grant on step 1, you can move on to step 2, which is your green card application. You can move on to it immediately if there's an immediate relative as your client. If it's a preference category, then you have to wait for the priority date to be current. And so that's why you see here an excerpt from the lovely visa bulletin put out by the Department of State every month. And you'll notice that VAWA applicants use the family-sponsored chart. So they may be classified as an F1, F2, F3, etc., based on the principal self-petitioner's relationship to the abuser. So even if the person's a derivative, they use the F category that applies to the principal self-petitioner. So once they are ready to file, the question is, are they admissible at that time? Or if they're not admissible, is their inadmissibility ground one that falls under an exception under VAWA, because there are some exceptions, or one that is waivable? If it's waivable, they'll use Form I-601 for it. And we will discuss that in 1 second. Also, just to note, if the person's a derivative, then the principal has to be granted their LPR at the same time or before the derivative in order for the derivative to do this. But there is a fun exception for VAWA derivatives, which is that if the principal doesn't get their LPR for whatever reason, maybe they don't want it anymore, or maybe they are permanently ineligible because of something that's unwaivable, then once the derivative finally turns 21, they become, by law, a self-petitioner in their own right. They don't have to file a new I-360. They don't have to have been eligible as a self-petitioner originally. They just become treated like one. They use the preference category that now applies to their relationship with the abuser, and they can submit their 485 and go through step 2 without the principal. Next slide, please. So I mentioned there are some special exceptions and waivers available if your VAWA applicant is inadmissible. So some of the grounds that qualify for exceptions, and by exception, I mean, the person doesn't have to submit anything besides possibly evidence that they're eligible for the exception. They don't have to submit any formal form or pay for any form. So exceptions are available for the following inadmissibility grounds: public charge, entry without inspection, unlawful presence bars, also known as the 3 or 10-year bar, as long as you can show a connection to the abuse, and certain exceptions that kind of relate to a minor's age. So if you've got a minor who's under 18, for example, we know that they don't accrue unlawful presence for the purpose of the 3 or 10-year bar while they're under 18. That's what I mean by those certain exceptions. And then waivers that are available to VAWA folks. There are special VAWA waivers listed here of these top 4 for communicable diseases, several different crimes, including CIMTs, fraud or misrepresentation, although not false claim to citizenship, and even the permanent bar if you show a connection to the abuse between their departure or their reentry. And so those are available especially to VAWA folks, although VAWA applicants are also able to access other waivers that exist for general family-based applicants, ones that require proving extreme hardship to a qualifying relative, for example, or smuggling. So there's lots of waivers available if someone's inadmissible. Next slide, please. Now, the actual process for VAWA LPR application is pretty straightforward and familiar. You're going to file the Form I-485 along with any waiver that you think is needed. If you've identified that one is definitely needed, you're going to file that once your priority date is current. Then you may have a USCIS interview for the person. Currently, interviews are very frequently being waived, especially in certain jurisdictions, but it's up to the field office to decide whether they want to interview a certain case. And it doesn't actually mean that the case will be denied. It's not like a sign that it's a weaker case just because it gets called to an interview. And something very important to know about these interviews is that they are I-485 interviews. These are not interviews about the VAWA I-360. And in fact, under USCIS policy manual, it is extremely clear. They are not allowed to ask questions that involve re-adjudicating, re-examining the I-360 elements. So if it seems like your interview is asking about the abuse or about good faith marriage, you need to point out that seems to be against policy. And you may need to call in a supervisor to get them to halt that kind of inappropriate line of questioning. If you've got a derivative child as your applicant, and they're in the as your client, I should say, and they're in the United States, their process is the same as above. If they do get called for an interview, it will most likely be with the principal. And if they're abroad, they will go through consular processing. So if they're abroad and the principal's in the United States, the principal has to go first through the 485 process. And what you do is, upon the approval of the I-360, you can file an I-824 for the child, and that will be decided once the 485 for the principal is approved. After that I-824 is approved, that gets the approved I-360 sent over to the Department of State so that consular processing gets triggered. This means that NBC then sends a welcome letter, and consular processing proceeds very much as normal if you do many family-based consular processing cases. And we've put a flow chart or links to some flow charts for derivatives into your materials as well. Next slide, please.
All right, so in discussing the VAWA requirements, there are some similarities, right, to the SIDG process. So for both, USCIS maintains exclusive jurisdiction over adjudicating the I-360. For the I-45 adjustment application, that could be with USCIS or it could be with an immigration judge. Parents cannot be derivatives on a child's I-360 VAWA self-petition either. Several inadmissibility exceptions overlap, but if inadmissibility applies, the waiver form would be I-601. For certain purposes, I-212 might be necessary for that A9A grounds, but the criteria are often different, and some exceptions and whatnot apply differently. And so that's very important to look into each ground to determine what might actually apply and what needs to be waived. Next slide, please. So key differences, again, as you mentioned with VAWA not requiring that LEA involvement, there's no state court involvement required for the VAWA. And there's a possibility, depending on processing times, that there's a conditional permanent residency adjudication first. The age at filing rules, so for VAWA, must file before 21 unless you can show the abuse was a central reason for the delay in filing, and then that child self-petitioner can file as long as they can prove that eligibility before 21, remain unmarried, they can file up to age 25, which is not the case for SIDGE. The age up protections as well. So the easiest one for the Child Status Protection Act is where the abuser is a US citizen. The age is frozen at the time of filing the I-360. For LPR abusers, that age is frozen at the CSPA age, and don't have time to get into all of that. Do recommend looking at the policy manual, other resources. There is this seek to acquire requirements within 1 year of visa availability. At 21, that preference category can shift as well. For self-petitioner derivatives, at age 21, they are considered a petitioner in their own right, and they keep the priority date of their parents' self-petition, so they don't need to file a new petition in order to then pursue that case. And I'll pass it back to Becca.
Thank you. And I'm not sure we have time to go through all of the practice scenarios we were hoping for. So let's do this first one and not the second one. So your client grew up, if we can launch both settings, thank you, awesome. Your client grew up being told that her father was an LPR, and he once even told her his own father had petitioned for him. And then he ultimately becomes abusive and she wants to file a VAWA self-petition. When must she file her I-360? Do about 15 seconds here. All right. So I've got a pretty close three-way race between before age 21, before age 25, and no deadline. And I think this is kind of a trick question, but I said that the best answer is that she must file before she's 21. So that's the general rule, like Leah said. However, if a difficulty related to the abuse is what prevents her from filing before she's 21, then she does have up until the day before she turns 25 to file. However, she can only do that if she was eligible before she turned 21. All right, and then just very quickly, question for Leah. What if she, thank you. What if she does not have a copy of her father's LPR card? Can she still file a VAWA self-petition?
Yeah, so she can. She should provide as much information as possible of why she believes he was an LPR, as much information about him, so his name or names, date of birth, if she knows his A number, as much as possible, because USCIS should theoretically have that information, and they should look that up based on the information she has to verify that.
Great, thank you. All right, and we'll skip the next practice scenario and move on to VAWA cancellation. Sorry, so I think that would be Leah.
What is this cancellation? So this is available for LPRs and non-LPRs. It's not something someone can apply for affirmatively. It's only available in removal proceedings. And here's the information, the form to use. It's the same as cancellation, that form EOIR 42B. While it's pending, they are eligible for a work permit under category C10. Upon approval, they can get permanent residency. but that is subject to an annual cap of 4,000 grants per year. So there is a bit of a wait, though please don't ask me how long, because I've heard different numbers, but it's all been years. So it is a pretty lengthy wait if granted. Next slide, please. So what is the eligibility for this? A lot of it is very similar to what we discussed for the VAWA self-petition, but it is a bit different. So it is important to look to see whether someone might be eligible for one or both. If they are a current or former spouse, child, or parent of an abused child of a US citizen or LPR, they might be eligible. Battery or extreme cruelty is also a requirement by that USC or LPR relative. They do have to show continuous physical presence, which is not an element of the self-petition process. There is no stop time rule here, though. Even if they're short of that 3 years, that is surmountable if they can connect it to the abuse. They also have to show good moral character. They have to be free of certain inadmissibility or removability grounds, depending on how they're charged on the NTA. Again, they also have to show extreme hardship, which is not a requirement anymore in the self-petition process, but is for cancellation. Next slide, please. We're a little short on time, so I'll just point out that for reasons why VAWA cancellation might be preferable, other than just the politics of being an immigration court and a judge maybe not allowing the self-petition time to be adjudicated, is where someone has aged out, like if a child's aged out of status to aged out of eligibility to file their own self-petition or to be derivative on their parents' status, or they're now married, or they divorced their spouse a long time ago. So I do recommend reviewing these slides for reasons why pursuing both, but why VAWA cancellation might be preferable or the only option to some. Next slide. Or I think there's a point here. I want to flag, so there aren't any derivatives for VAWA cancellation. There is this possibility of parole. But I've heard mixed reviews on how possible or how smooth that process is and how available it is in the reality. But under the statute, there is this possibility of parole for children and parents of children granted cancellation. And I'll pass it back to Becca.
All right, thank you. So we wanted to close with just a few generally applicable considerations to survivor-based relief. First one is are the protections under 8 U.S.C. section 1367. And this law provides two primary protections to anybody who has filed a T or U application or a VAWA self-petition. The first protection is against USCIS making an adverse decision based on a tip they got only from the abuser or abuser's households. And when I say abuser, it could also be a U perpetrator who's not a domestic abuser. So USCIS can't make the decision based on that information from that exclusive source. Another protection is against disclosure by DHS of any information relating to this applicant, except for legitimate law enforcement purposes, assessing public benefit eligibility, national security reasons, and a few other reasons that are listed right there in the statute. It's a very strict protection against disclosure of information. And these are very good and important protections for folks who are vulnerable, but they do have some kind of inconvenient or I wrote unfortunate side effects for people working on these cases. And one is that you can't use most online case information tools to learn what's going on with the case, because that could violate the disclosure provision. And similarly, you can't call USCIS customer service about this person. And generally, because these protections apply to information about the applicant themselves, as opposed to about the application, you can't even call customer service to ask about other applications the person may have filed. So that can make it really hard to find out what's happening in the 3, 5, 8 years that this case is pending. For represented applicants, there's an okay workaround, which is that their attorney can email the service center processing their application to ask whatever they might have asked to customer service. That's how they can reschedule biometrics. It's how you can make an expedite request. But for a pro se applicant, you're going to be only contacting USCIS by mail. Next slide, please. Another thing to mention is the any credible evidence standard. We've brought it up a couple times. What it says is that survivor-based applicants are not bound to produce any primary evidence in particular. And this rule recognizes that survivors have a limited ability to safely obtain certain records after they've been the victim of a crime or abuse. But note that this is an evidentiary standard and not a change to the burden of proof. It's just a change to the type of proof you can use. So it says if USCIS is asking for X document to prove something, you still have to prove that thing, but you can use Y document as long as it's credible and on point. And this standard does apply to all of the forms of relief we discussed today. Next slide, please. All right, so this last slide just draws your attention to several memos that we've put in the materials regarding how to get prosecutorial discretion due to the client's status as a survivor of trafficking, crime, or abuse. And there are directives that apply to ICRO, OPLA, and even all of DHS that take into account and give certain levels, depending on which memo you can use, of protection and persuasion that you can use when requesting prosecutorial discretion to get your client's goals met, whatever they may be. All right, and with that, we might have time for one question. I'm not sure if CILA needs to close us out.
Unfortunately, I think we don't have any time for live questions, but thank you so much, Rebecca and Leah, for this presentation and also for answering many questions in the Q&A box. We just have a few things to go over before we end the webinar. As mentioned at the beginning, this webinar was approved for Texas CLE credit. So if you would like to receive that, please fill out the CLE form. The link is being dropped in the chat, and I'll also email that around afterwards. We also really appreciate your feedback, so please take some time to fill out our feedback survey. CILA also has a few resources on this topic. We have an ongoing blog series right now called Supporting Our Clients in the Interim by Rescreening for Relief. We have a post on U visas and a new post on T visas. We also have a resource online about OTIP letters, which can be available for children who were trafficked. I want to remind everyone that CILA is here to answer your technical assistance questions. So if you do have any lingering questions from today's webinar, you can submit them to us. I believe the presenters are happy to be reached out to as well. But if you have specific questions about these forms of relief and unaccompanied children, please feel free to submit via our online request, or you can email our general inbox. We also have a social work program that provides technical assistance. And this is really great because it's not just for social workers. Any legal staff on the call today, if you feel you have a technical assistance question that goes more to social services for your client, social work issues, please reach out to us. We have a link for that as well online. And you could reach out directly to our social workers, Maria and Marisa. You'll get these slides afterwards so you can read more about what that encompasses, but we encourage you to reach out and check out this great resource that CILA put out on being an ally, working with and advocating for LGBTQ plus unaccompanied youth. I also just want to take a moment to plug our pro bono platform. I mentioned this earlier, but CILA hosts a pro bono platform where we have cases nationally that you could take, you could send to a friend. We also have a pro bono newsletter that goes out quarterly, so please check those out. And finally, please stay connected with CILA. Like we mentioned, we have an online resource library with written resources. We have listservs, 6 working groups. We have a monthly newsletter, and we answer technical assistance questions. And please continue to attend CILA trainings. And with that, thank you so much, everyone. We really appreciate your time. And thank you again, Rebecca and Leah and ASISTA.